Alrighty, peace, love, and law, everyone. How is everyone doing on this beautiful day? We give thanks for each and every last one of you that are tuning in with us right now. Welcome to the In God We Trust Academy podcast today. And today we're going to be speaking to you on how to handle apartment leases. So you already know what to do. Hit the share button, show us some love, drop some ones, let us know you with us, let us know where you're from. And hey, let's keep this thing going. Let's keep it jumping. As always, right? So let's do this. Make sure you hit that share button. Show some love out here. Do your part, cause I'ma do mine. Maryland in the house. What's up, Maryland? That's what's up. We got Maryland in the house. Yo, it's always a beautiful thing to do this, yo. I enjoy doing this. Hope you guys enjoy listening. All right, we're going to get started in about 3-4 more minutes. Going to let you guys get time enough to get up in here and we're going to talk about it. But until then, let's vibe out.
Raise your glass to this.
Mustard. Straight up, man. Let's vibe out.
Through all the struggle, we making it. In the kitchen, trying to take to the street. Man, get rich and keep them geek. Man, the catfish took the whole street. No flounders, y'all ain't seeing me. Them babies, man, they gotta eat. So it's real when a nigga ain't owe me. Say it's real when a nigga wanna take from me. Boy, I lay my head on English Street. Them 5 points all in me. My blood niggas, they gotta eat. On the hill, you straight for life. If I make it, we take a flight. Just want my mama be proud. Real son, I living that good life. The life I live got 13 straight. Know some hood niggas on their third strike. And still my niggas jug every night. Cause the government ain't acting right. Got some cousin locked up, seeing light. Got pedophiles out run the street. That's the reason I take 2 to 3. You fuck with me and I fuck with you. All my niggas guaranteed to eat. All I ever wanna do. Take 2 to 3, you know it's true. Take 2 to 3, you know it's true.
I gotta feed my babies.
I gotta feed my babies.
I gotta feed my hood too. I gotta feed my hood too. All I ever wanna do.
Hey,
Take 2 to 3, you know it's true. I talk like I'm water whipping. God, I'm gifted, my dimension. Away from all you niggas. Death to the gun off all you niggas. Death to the guns off all you niggas. Hell for the gun, got a handful of blood and a handful of drugs. Been awful nigga, roller nigga.
Dirty bricks and my word is spitting and I hurt your bitch.
And it's all too killer.
36 in my dirty kitchen, I just started fishing.
And that's boss, little nigga.
Work my wrist just to merge the shit, I gotta work to live.
I got scar, little nigga.
I just burnt the bed and with the earth I'm giving from the weed, man.
Sippin' hard my liquor.
I been in control of shit. Y'all just not noticed it. Check out my actions, I'm focused, bitch. But boys and flunkies ain't fucking with. Cash in the swagger, hot poker chips. Tryna go large just to soul assist. Overdose on that syrup I'm rolling with.
Oh Lord, these nigga right
All I ever wanna do, all I ever wanna do. Take 2 to 3, you know it's true. Take 2 to 3, you know it's true. Gotta feed my babies, man. Gotta feed my babies. Gotta feed my hood too. Gotta feed my hood too. All I ever wanna do.
hey, take 2 to 3, you know it's true. Man, I gotta feed my babies. Ain't this what we do it for, man? Ain't this what we do it for? You know what I mean? Like I say, man, I just always give thanks to each and every last one of you guys for tuning in with me, right? And I just, appreciate we could be doing so much more, but, we're going to get there. But right now we are tuned in and you guys could be doing other things and you're here with me. So it's always a pleasure to be able to bring this information to you guys as well, share as much as possible as I can of the knowledge and wisdom that I have, and hoping that it helps you guys on your journey and you do apply your due diligence as well, man. So I just give thanks as always for your participation. We give thanks for the Most High, the Creator, for this beautiful day and this present moment, still being able, the fact that you're able to get up and do whatever it is that you need today because you're still in your right mind. You're still able, okay? So, yes, let's make sure that we do our diligence, right? No time to be lazy, no time to make excuses. Excuses does not solve or bring us solutions. So let's make sure that we get up every single day and do what it is that we are supposed to do, man. So we got people that's dependent on us, right? Our family, our children, our community, our loved ones, etc. So, let's just make sure we get up and do our part. It's the easiest part. Hey, everybody want the easy way. The easy way is to lay in the bed. The easiest way is to not pick up a book. The easiest way is to not care. And a lot of people choose to go that way. And the only thing they can do is look back at those who decided to chase their dreams and didn't take the easy way. The one who sought out the hard work, the one who took the challenge no matter what. So again, we give thanks for you guys on that, right? So let's make sure that we just keep pushing, man. Again, anything that you guys hear from this point on is for educational, religious purposes only. So anybody seeking any form of legal advice, please do seek a legal advisor, as it is my religious duty to speak my religious truth and experiences with you guys here today. All righty, so let's talk about it, right? Leases. First of all, a lease is a promise to pay because you're promising to pay something based upon some fulfillment of obligations. Now, excuse me. Some leases are different. It all just depends on the actual landlord and stuff that you're dealing with based upon the wording of the contract. But for the most part, if you're dealing with big residential areas and stuff like that, these big corporations, then you have to understand that this is a form like an investment because they go under what they call securitization. They take all the leases and they put them in what they call a pool and service agreement, right? Well, anytime that they convert anything into a financial asset, it has to benefit all parties, even the creator, which is yourself. Right? And so we're going to be speaking to you guys along the line of those things today as well, man. And appreciate the stars there, 99 stars, Vici Slay. So I appreciate that as well. So we're going to be speaking on these things with you guys today and how to, help you. Because again, I keep explaining to you guys, anytime we're dealing with a promise to pay, we have to stop doing blank endorsements. Stop doing blank endorsements. Stop just signing your name. That is a blank endorsement and allowing the bearer to handle that particular financial asset or instrument in any way that they may seem, relevant for themselves. Right? So what can we do when it comes to these type of situations, right? So we're going to jump into that with you guys today. And make sure y'all drop some ones, hit the share button. And let's get into this. All right, so first, what is a lease? Okay. And a lease is a legal contract granting possession of property in exchange for rent. Granting possession of property in exchange for some rent. And it represents both a right to occupy and a promise to pay, making it an equitable interest. So a right to occupy and a promise to pay, making it an equitable interest. So why should we protect this equitable interest? We should make sure that we safeguard the security deposits, any form of improvements, and our possessory rights. All right? I'm going to say this again. Security deposits, improvements, and possessory rights. If your particular contract is being used in the form of securitization, that goes along with the form of security deposit as well. All right? So we need to learn how to make sure that we make our claims on this type of stuff, right? So now the improvements, any form of improvements that you may have to make. Again, I understand landlords and things like that. They're, you know, the people they have working on stuff, or yeah, they just don't do a good job, or they're not on time, or you're constantly having to do, or even come out your own pocket for things because you can't wait on them to do stuff. And it puts you in a place of, you know, we'll just say situation where it causes you damages and harm. Okay. And that goes to things like mold being in your apartments and all of that stuff as well. But see, you got to understand contracts when it comes to this, right? Because all obligations have to be fulfilled in contracts. And the key word for you guys, especially for those of you that be dealing with evictions and stuff like that, I keep telling y'all, read your contract. It's equity in your contract at all times. Why do I say equity? Because equity compels performance. So they must perform according to the obligations that was in the contract. If anything is slightly off, if anything is done wrong in any shape, form, or fashion, that is considered a breach of contract. That is number one, right? All right, so you got to understand that part. And you have to ask yourself, why are you paying the full amount for half services? All right, we're going to get a little bit deeper into this as we continue to go. Make sure y'all continue to like and share to keep the activity going. All right, so now that we know this is to maintain a legal standing and control over your lease agreement, right? So what I always tell people is this: you want to convey the lease address into a trust. Okay, an address is considered intangible property. And an address of an apartment is considered the legal description. Okay? It is considered the legal description of the unit. So if you take that legal description there, since you are in control, and remember, if you're in control over it, you have the right of use of it. We need to convey that address. And this protects your possessory interest by aligning it with the trust protection. And it ensures that control over the lease is preserved under trust law. So that means that no matter what, for the whole entire time of this whole particular, and you want to do the lease too, so you want to just make sure you place everything there. But you have the full rights and all interests of the whole entire contract. So until everything in that contract is fulfilled, and see, that's the beautiful thing about trust. Everything has to be fulfilled to the fullest. And if it's not fulfilled to the fullest in the trust does not have to let go of the property until it's all obligations that's dealing with the contract, etc., is fulfilled. And if not, we don't move. We must protect our equitable interests at all times. And sometimes that may have to be done through injunctions. Right? Because certain statutory courts does not have the power to uphold your form of equitable rights. So you need to understand that. And it is intangible property. It can be conveyed, and you need to do that. All right? Can you see, touch, and feel an address? No, but it is the legal description of the apartment, which you do see, touch, and feel, right? And which you do have added fixtures and stuff like that. If you do anything to it, just know you have more power. They owe you, right? They owe you. What's up, fam? I know who that is. Ashley Larry. What's up, bro? But yeah, you gotta understand that to the fullest, right? So once you convey this ensures controls over the lease and is preserved under the trust law. So you want to create, either have a trust or you can create an existing trust. Now, mind you, a conveyance is what starts a trust. So you can literally just right then and there convey it and create a trust in the middle of the conveyance. All you have to do is state who the trustee is, the grantor, trustee, and the beneficiaries. Boom, you got a trust right through a conveyance. And that means that based upon what you write in the conveyance means determine the terms or the rules and regulations in the use of this property is considered the law in dealing with this particular property, right? So understand that as well. Okay? So now that has happened, we want to make sure that we include the details of the address, the lease term, and the trust as the new holder of the possessory interest. Possessory interest, right? Okay? So you can literally say, I hereby convey all possessory rights and equitable interest in the lease for the address, the trust name, effectively, immediately. And we're going to notify the landlord, provide the landlord with a copy of the conveyance document, and ensure compliance with these lease terms, right? And we want to make sure that you can record the conveyance if necessary. In some jurisdiction, recording conveyance may be required for public notice, and you can do and make public notice, right? But we're going to make this on by the UCC for a reason, right? Okay, so now you have to understand about that part, that when you do sign these things. Now, just to speak on a little bit of the power of your endorsement. Why does your endorsement matters? Because again, some of these contracts, especially when you come to deal, and I'm not talking about when you're dealing with individual private landlords, et cetera, stuff like that. I'm speaking on these ones that you got, it's 300 unit apartments and all this type of stuff where, 400 to 500 units there. All of those are always in pooling service agreements. They always securitize these things. They always make them in a business platform of an investment. You're supposed to be in part of that investment if you retain all your rights and interests and as the creator or a grantor of all obligations in the note. If you do that, then all of those proceeds is supposed to be coming to you. But if you sign a blank endorsement, this is where the situation comes in at. This is the reason why even after you've been evicted, a third party can come and say, hey, you still owe some money for this particular lease. And they're still trying to get it out of you. They'll put it on your credit report. They'll do all kind of things, okay? Right? Yes, it's something I put together myself. Absolutely. All right, so now you have to understand why endorse the lease: to formalize your control over the obligations and rights within the lease. And when we say endorsement means not just your signature. That's a blank endorsement. Well, that is a form of endorsement. It's blank. But when we speak on endorsement, we're speaking on specific and special endorsements, right? So we want to make sure that we always say for value received based upon the what? The consideration of the possessory rights in the particular unit. All right. So now pay to the order of. It should be yourself. And the reason why we're doing this is because we want to make sure that if this is ever securitized, we want to make sure that we claim all dividends, interest, and principal payouts that will be created from this particular note and going into escrow. Okay. You have to understand that part. So I always put redeeming lawful money, but the main thing is, even if you don't put that, just make sure you retain all rights, titles, and interests as the grantor or / creator of all obligations. So for value received, acknowledge the exchange of value under the lease, which is if you gave a form of security deposit and you gave a promise to pay. Your promise to pay was value in exchange for the possessory rights of the actual unit, right? And which is also includes the address, etc. All right, so now pay to the order of, it directs the financial obligations to you or the trust, however you want to do. And when we say retain all rights, this ensures your equitable control over the lease and obligations. All right, now, a lot of y'all be like, well, what if they stop? They cannot. If they try to stop you from how you sign, then it's very important that you protect your rights. Because now they have to show what chartered their business to limit your ability to contract. So what delegation of authority did they receive from the state to limit your ability to contract? They can't do that. None whatsoever. And if they do try to get you to waive a right, then that is a attempt of what? Fraud and deceit. Why would you ever want anybody to waive their rights unless you're going to be in a form of deception? Right? So you got to understand that. So are they attempting to fraud you based upon you waiving your rights? Because it takes you away from being able to do certain things and make certain claims. We don't want to do that. And we're not going to do that. So we're going to retain all rights and interests, right? All rights, titles, and interests. Make sure we do that. Now, you can endorse anywhere that they're making you sign, for sure, in relations to. If you have to allonge, then you can. All right, so now that we got the endorsement of everything, we got the conveyance of the actual trust, then now we want to make sure that we do the UCC1. Why? Because you always have to give a security deposit. So once you give a security deposit, that goes in as what? Collateral being held as secured interest, as well as the note and any other form of the property. So you can put the address, the unit itself, the note within itself, and the security deposit. All of this should be filed on the UCC1 to protect your interest in this situation. So a legal UCC1 is a legal form used to declare secure interest in personal property obligations, including leases. So we're going to make the claim on the obligation because remember, whatever is said in the note is part of the secured interest. It is part of what is in the collateral. So all obligations must be fulfilled. Drop some ones if you understand me, right? Let me check y'all vibe right quick. Let me make sure y'all with us. Drop some ones, hit the share button, show some love. Because you got to understand that part. The obligation is part of the secured interest. It must be fulfilled. The obligation is valued within the actual promise to pay lease. So if they said that you were supposed to be in a gated community and the gate doesn't work the whole entire time, that is a breach of the contract. It is a breach of our secured interest that we have here. That's our situation. So make sure you know what's going on. Let me see y'all with us today. All right. I think y'all know what's going on. We just checking y'all vibe. All right, so now, who is a secured party? Yourself. You are the secured party. Why are you secured? You should be secured in all obligations that is afforded to you. You're secured by the secured deposit that you placed in, okay? And you're also secured by the promise to pay that you gave in order to have possessory rights of the particular unit. Do everybody understand that? If you do, show some love and type in the chat love. Let me make sure before we move forward. Let me know. This is I'm not going to say it's very simple to understand because it took me years to understand this, but we here though. So I just want to show you. All right. Just want to show you. Okay. So now that I know y'all with us, now the debtor is the landlord or the leasing entity. Why? Because they owe the obligation. They are holding the security deposit. All right. In place of fulfilling the obligations for the possessory rights that you have. Okay. So make sure we understand that. Okay, so now, described in the collateral, it should have the lease agreement date and the address, including all rights, interest, security deposits, and tenant improvements. Tenant improvements. Listen, I want y'all to get this part now. Tenant improvements. So that means that if you got to improve anything, and I mean anything. See what I'm saying? If a dryer came with it, etc., they were supposed to have been fixing the dryer all this time, and they haven't fixed it, and you have to go out and go buy one for yourself just to be able to dry your clothes, etc., you can consider that a breach of contract as well for them not, or you can send out an invoice to them in equity, letting them know what they owe you for the restitution. Now, they're not going to just owe you the cost of it. They're going to owe you more because of the time and labor that you had to put to go and get it, bring it in, hook it up, do even if you had to pay somebody, they owe you all of that, right? Now, that's something that you got in order to keep the apartment, especially if it comes to evictions. Because now you have proof that you were secured in all obligations that was afforded to you in the collateral. And if they were not fully done right, then that is a breach of contract. And now you have the right to restitution based upon any form of harm and damages that has been caused against you. Remember, especially once it goes into the trust ain't letting nothing go until everything is fulfilled for the beneficiary. And if everything's not fully fulfilled for the beneficiary, the trust do not have to leave. at all. So that means that if the actual lease term says, I don't know, if it's a 2 year, 1 year, whatever, you have the whole 12, and they can't make you leave for nothing until all obligations is fulfilled on their end and both ends, right? That has to happen. And I think a lot of people miss that. So we want to make sure that we put that down there. We want to make sure we retain a copy and submit the UCC1 in the state where the lease property is located. And you can send them a copy of the UCC1 because you're the one that's perfecting your interest. All right. So since we did a secured deposit, that also leads to form of taxes, but we'll talk about that in a second as well. So the process by which the landlord or lessor bundle lease income into financial instruments sold to investors is securitization. So the lease may be sold or signed without notice. All right. This is why you should be concerned. But this is why you should always protect what's yours. So protecting the equitable interest ensures that your rights remain enforceable regardless of the securitization. I don't care who got it or where it went. And that also means that if it goes under securitization and this note is given to a special purpose vehicle, then that literally means that the individual or the landlord or whoever at this particular time, they no longer have the negotiable instruments in order to enforce. Right? So they're not the holder in due course in order to enforce it, which also is another thing that we're going to speak about. All right. So now, if it deals with the trust, you could do a 1041 file if the trust received income and incurs expenses related to the lease. Yes, you do have expenses, so that's what you can pay for. Schedule K1 is issued to beneficiaries for income or any form of deductions. All right. So lease-related improvements and repairs may be deductible if the lease is held in trust. So again, if you make any form of improvements when it comes to the security deposit interest, we can submit a W-9 with the trust EIN to ensure proper tax reporting on any interest earned here. So 1099, we can do a 1099 miscellaneous based upon the payments, or we can do a 1099B as well based upon the barter and exchange that is going through here as well. So either or would suffice. Okay. So what is the purpose of the security agreement? It formalizes the secured interest in the lease, ensuring legal protection. Okay. And we want to specify the lease related to interest, security deposit, possessory rights as collateral. So your security deposit and your possessory right and all obligations that is supposed to be fulfilled for you is what is in collateral. That is your secured interest that should be placed on the UCC1. Okay. That is the secured interest. So let's just talk about it. So now let's say you guys got your contracts, and when it comes down to your contract, like one, you have to read them. And I don't have to tell you this because y'all come to me all the time saying, oh, well, they didn't do this or they didn't do that. And I got mold in my house. I got this. I got all of this type of stuff. Well, mold breaks the code of the state. So you need to find in the code of the state where they're supposed to be up to par in their standing. So you guys are going to literally have to do your own research on this too, because states have, a building code that everything has to be set up for, especially when they start being in business and residential property and stuff like that, right? Even if you are dealing with commercial property, it's still the same thing, right? If you're leasing commercial property, same thing still applies here, all right? And all commercial property are usually securitized too. So understand that part, all right? So my point in me saying this is like, just make sure that when you take control, because all of it is in your interest. So make sure you read and make sure that the building is up to par to the codes of the state. If not, that's a violation. All right. And also read the contract in fullness and thereof. Everything that they said they're obligated to do, they have to do it. You people have to stop being passive. I don't care if it's something as simple as a light not being where it's supposed to be. Everything that they said they will offer to you in that contract and you're paying for it, they have to give it. I don't give a damn if they're supposed to pick up the trash all the time and they don't pick up the trash on one day they were supposed to pick it up. That's half services that weren't provided. That's a breach of contract. We want to be fully secured in our interest. Okay. So the landlords in Ohio have to pay 5% interest annually on every security deposit here. See? That right there. So I just want to say the mold addendum, yeah, I wouldn't even sign to that. Because again, that still deals with the violation of the property rights. Right? So I'm not even going to deal with something where somebody's not going to claim their responsibility for mold. But if they're saying that you're the cause of the mold, then that could be a different story because people can be caused based upon how they deal with the housing. But I'm just trying to show you guys how to fully protect your interests. So a UCC1 is very necessary. Okay? I know a lot of people feel like, oh, well, you don't have. Yes. Article 9, read it, of the UCC. All these corporations supposed to protect file their secured interest in order to perfect it. If they don't file it, they didn't perfect it. That's another thing. And most of them don't because, well, it's harder to transfer. It's easier for me to take a promise to pay, a negotiable instrument, and put value received if I was the chief financial officer and just put pay to the order of whoever I want to, transfer it to, than me having to go counsel a lien. I got to counsel a whole lot of different stuff, or I got to do a UCC3 to do an assignment or transfer it to the next entity, and so on, so on, so on. That takes money, that takes time, etc. Than just me having to pay to the order of and transfer it, right? So, but we not aware of this is what they're supposed to be doing. This is why I'm telling you, you go do it. Because once you do it, you perfected your interest to the fullest, right? And everything has to be followed. If it's not, okay? If it's not, that's the situation, okay? That is the situation for you. And they also have to fully go by the consumer law as well when it comes to, because basically what they're doing is lending you a form of interest in a unit. All right. So that goes under the truth in lending as well. And they're going to determine things by credit score and all of those extra stuff. So you got to fully be able to learn and protect your right. But just start asking these people this too, though. Can they prove your ability to pay through they're not even credit bureaus, so credit agencies, these credit reporting agencies. Can they prove your ability to pay? And the truth is they can't. They can never prove your ability to pay, right? Because all circumstances are different. And if you are in a dispute of anything, they could never use that to declare whether you have or have not the right to, do they have the right to use that particular information? Because I can't use any certain particular information that's in dispute. They're not going to let you do it because we don't know whether what's true or not in order to use the information. So that's why I always say, like, anything that is in dispute, that you do have in dispute, again, it's nothing they can do about it. And I always tell you guys this too as well. Credit is a right granted. So credit has to always be offered. So that means they have to always come up with a credit offer for you. They're never supposed to deny you. Now, your shit might be high. You see what I'm saying? Like, your interest rates and all of that stuff might be high because of, your history ain't too great, but they have to make you a credit offer based upon your ability to pay. All right? And that is one thing they have to do. So when it comes to these evictions, use your contract. And I'm going to keep saying this. And it makes it even stronger for you when you protect your secured interests. So again, what is supposed to be the secured interest that we're speaking on? So we're speaking on the address, the lease terms, all possessory rights, any form of interest and dividends and principal payouts, if it is securitized, right? We want to make sure that we have that and all obligations that needs to be fulfilled, because all obligations, remember, performance holds value. Okay? If we're not paying something, we're performing for something. And usually, I mean, that's all what this is performance, because we don't have the ability to really pay, but we do have the ability to perform, right? Perform the obligations that are fully requested. Okay? So now, when you do perform here, make sure you do what's supposed to be done. This business, right? And this is why we have to be taught this. There's so many children, kids that turn 18, 19, stuff like that. They finna hop out here, go get an apartment and don't have anything, no idea about a contract or what's supposed to be done. But we have to start protecting our interests. Even when it comes to credit cards, protect your secured interests. All right. You got a contract, and all obligations in that contract is afforded to you. All right. And you can also put the credit card, et cetera, down in there as collateral and secured interest, the account number, everything that's involved with it. We have to secure our interest. Same thing with a mortgage. Secure your interest. They owe you all obligations that's afforded to you in the mortgage. And then now once we do this and we start, like, let's say we start making certain claims. And what I mean by that is, like, for instance, the creditor is obligated or is subject to all claims of the debtor. So that literally means anything that we're asking for, right? All right, anything that we're asking for in relations to the actual contract, they must be in full transparency. And if they're not in full transparency, that's where the situation takes place at, where you get to, well, it's a breach of contract. Somebody says, I'm in a private landlord apartment and I have mold and field mice, and he trying to put me out for not paying because I fell on hard time. I need help. Well, you need to look at your contract. That's the thing you need to do. You need to read your contract first and foremost. And I always tell y'all, listen to this, y'all. Stop waiting on these people to make a threat and follow through. The first threat that you receive about any damn thing, if I was you, I would just go straight to the court and do an injunction. Because now you can stop them from doing what they're trying to do based upon them not fulfilling their obligations. And they have to, because if you wait on them to take, let me tell you what happens when you wait on them to take you into court. When you wait on them to take you into court, what happens is that the complaint that being made is how the court is going to run. So based upon the complaint that is made, this is how the court is going to go. And the complaint is there's a contract. You didn't pay. Well, you paid this amount of time. You haven't paid this amount of time, and you owe. And you have exceeded the amount of time, right? That's all they're going to look at. They're not going to look at anything else but the fact that, and this is the reason why you got to know how to handle court. Got to know how to handle court. And that literally means this is why we don't have to do, you don't admit the contract. I have no knowledge of. I can't remember. All right. So what is all the obligations is to be afforded in the contract is what needs to be known. But this is the reason why I say beat them to the punch, because now we have to go by what I'm saying. So now I get to point out all these obligations that you were supposed to fulfill and didn't fulfill, and whether it's any form of equitable remedy, declaratory judgments, injunctions, things of that nature, right? Or even could be a tort claim based upon you having to receive some form of damages. But my point in this is, like, once you do this, now they're compelled to come show why they haven't performed. Okay? It's a difference. they're compelled to show why they haven't fully performed. All right. And now they have to answer to everything they haven't performed about. And now it's not about the payments that you made or et cetera. It's about their performance and their obligations to perform, which you have a secured interest in. Because guess what? We're going to enter that UCC1 into it as evidence, showing that we perfected our interests in all obligations that were supposed to be performed according to the terms. That's the difference. I mean, counterclaims and recoupment is great, but some courts don't want to deal with counterclaims. Some courts feel like they'll tell you, hey, I'm just going to dismiss this case, and then you can go get your remedy from another court, because they don't want to go through all of that in their court. So that's why if they don't give you that in that particular court, then you just need to go file an injunction immediately. Sometimes they will just go with the flow with the with the actual landlord. So that's why I fully believe in beating them to the punch. You only got one time to threaten me, especially when I know you haven't been fulfilling everything, right? And if you ain't fulfilled everything that you're supposed to fulfill, then yeah, I'm in here. So the time you make a threat, and we already been going back and forth about you not doing what you're doing, I'm in court already. I'm not going to give you the chance to make the move on me. I'm going to make the move, and they're going to be responsible for all court fees and legal fees and everything else that they're supposed to be responsible for to the fullest. Right? So that's what you got to do. That's what you got to do. How to endorse with the electronic signature? All you got to do is send in a launch. You can send in a launch and tell them that this is your endorsement and it needs to be attached to the particular contract. If they fully disagree with that, then we go into court. They have no choice because you do have that right and power to do that. How does it work for state programs that pay for your rent? I mean, it's still the same thing. It don't matter who paying for your rent. Are they fulfilling the obligations? Are they doing everything that they're supposed to in their contract? Because, again, we are too freaking passive as people. And they not passive with you. That's true, too. They will give it to you in equity at the appellate court. And the appellate court is a place of equity. So I definitely agree with that as well. But the due diligence is, again, like I say, I don't want to have to go through none of that shit. So as soon as somebody try to make a threat or claim against me, then I know you haven't been fulfilling our obligations. I'm always on the offensive end. I'm tired of being on the defense. I don't want to be on the defense. I don't have to be on the defense. And most of us just sit and wait until, well, I'm just waiting. Because most people I deal with is, well, I'm just waiting on them to take me to court. When they take me to court, I'm going to be ready. No, we can just sue right now. We don't got to wait because we already got our claims. So why wait? You know? Why wait? That's literally my thing on this whole entire situation. Why wait? You know, and that's just like I was saying, like, and if you know it's been securitized, we can also make sure that they come through, that they have to come through and make we can motion compel them to show that they have the right to do some of the things that they're doing, which means that they have if they have the right to, let me see, how can I say, because I was trying to read something at the same time. I just forgot my train of thought. Excuse me. Yeah, you can put your funds in lease to an escrow, but you're going to have to do more than just talk. You're going to have to show it to them. That is a fact. They can be billed too. People gonna ask. So you got to be ready to tell them. So we want to know. But I just really wanted to put this out to you guys and help y'all understand. I mean, and this is what I will say. There is no two cases that are alike that will be treated the same. Let me just put it like that. And that has everything to do with the individuals that you're dealing with, as far as the court, etc. All of that stuff. It comes into play. You feel me? So like I say, I agree with everything. But y'all, please, man, for real, no. Like sometimes you gotta fight. And as easy as it sounds that I'm saying this, sometimes it's not based upon what you have to do. But what I've learned the most is this. If you got the most compelling evidence to show proof that there's no left or there's no right or there's no up or down for them, you gonna win. You gonna win. Facts. Well, let me explain what equity is in all courts. Equity first means what's fair, what's just, and what ought to be done. So when you move in equity, equity needs to be equity is a motion to dismiss for whatever reason. That's equity. So if I do a motion to compel the court to, motion to compel the plaintiff to show proof or prima facie evidence of their delegation of authority to bring this claim, which means they would have to show proof that they have the original note or they was given some form of chain of title, etc. That's equity. So, equity is also, because I'm trying to explain equity, because equity is there at all times. And we have to realize this when it comes to making them show proof of things and stuff like that. That's part of due process. Evidence is part of due process. And if certain evidence and things is not brought forward to make a claim, that becomes a violation of due process. All right. Brittany Golson, I don't even remember what I was saying. What did I say? I just forgot back there. But yeah, man, so we got to do better. I've been standing in the same case for almost 2 years, LOL. I feel you, because it took me a year. It took me a year to get mine situation with the car done. So it could be time. Facts. Equity is before the judge at all time. But again, guys, we can't do nothing. Sending affidavits. Affidavits is just a facts. Evidence of facts. So just putting in the affidavit saying something doesn't do anything. But if you have an affidavit stating facts, and then based off of these facts, you compelled a motion to happen, now we move the court. Do everybody understand that? Bruh said he look like he about to get his ass. Hey, I feel you, man. It can seem like that sometimes, man. But evidence, man, is nothing. And that's the reason why I be like, okay, well, if you got brought to the court based upon some party that you say, hey, I don't got a contract with this party, and they bringing me to court. So the first thing you need, they be like, all right, well, there's a contract I have no knowledge of. Or we're going to hit them with the Woody response. I do not recall. So I need more proof. In order for me to see more proof, I'm going to need the original notes and the chain of title so we can know. Because otherwise, I don't know what they're talking about in here today. It's alleged that this is your yeah, but this looks like a copy, and I can't even say that's mine. I don't write like that, or I don't write in this color, or whatever the case may be. I can't tell unless I see the original. How do I know this is the copy? I don't know. gonna need for y'all to literally go read law. Somebody said, I thought motion was a request and gives the court jurisdiction. The court already got jurisdiction. You were summoned and subpoenaed. You were summoned. They already got jurisdiction. It's already done. But here's the thing. The court starts lacking jurisdiction when you can prove there's no claim, there's no cause of action to grant relief. Now the court loses jurisdiction. How do we do that? By doing a motion to compel the plaintiff to bring the original note. Because I don't recall signing this with you. I don't recall any of this. So I'm going to need full blatant proof and here up on the court today. So that's it. So now this is my point. You got to look at it from that point. Because, like, I used to look at it that way where everybody was standing. So I really started understanding and reading, like, okay, so now that I know this, so if they can't bring this court, now that they can't compare, if now the judge have to understand about evidence and the evidence that I'm asking to be brought in order for them to bring their cause of action or show delegation of authority to make this claim. And if they can't do that, guess what? The court lost jurisdiction now. There is no jurisdiction here, and the court has to dismiss because there's not a claim for them to govern or adjudicate over anymore. So now, that's a formal challenge to jurisdiction. It's gone. It's gone. It's gone. Right? That's the same thing. If they securitize your lease, same thing. Somebody said, what's the difference between equity or negligence under tort? Okay, so again, equity means fair. It means just. It means righteousness. It means to do what should be done. So let me help you understand that. That's equity. Negligence under a tort, that means that if you go and get a tort and make a claim, then you're looking for equity in that tort claim, because based upon the harm and damages that has been done, you're looking for what's fair out of it, whether it's restitution or this individual to be placed in arrest or whatever. That's equity. Remember, equity is what's just literally what's fair, just, righteous, and what should be done. So if there is no cause of action to grant relief, then by equity, the court should dismiss the case, which means there is a performance. Equity always compels performance. Always. Boy, listen. Jesse Invest. Let me ask y'all a question. Why y'all do this stuff? Do y'all hear what we talking about? And then somebody pop up with a question that says, is there any way to get an invoice from a dealership taking that to bank for redemption to treasury? Why would you ask that question when we're literally talking about evictions and stuff like that? So I guarantee you, if you ever go through an eviction or something that happened, you ain't gonna know shit because you didn't listen to what we were saying during this time. And y'all gotta stop doing that. And no, you can't do nothing like that. Why don't you learn how to, one, operate within the credit system, get your credit score up the way it's supposed to, clean it up, learn how to properly endorse contracts. And guess what? The Treasury and the Federal Reserve, and through the discount window, they're already responsible for doing it in the first place. They're already responsible. So you don't got to go do all that if you truly learn how to operate in commerce. That's a fact. Learn how to operate in commerce. Because I ain't telling none of y'all to go do that shit. Shouldn't you be getting money back from the monies we paid? Nope. What you want money back from? From where? Tell me where. Where do you want it back from? I'm listening. Where you want the money from? Where do you want the money, money, money? Tell me where you want the money to come from. We are waiting. The IRS, what money? See, because if you want stuff like that, if you want to receive something back from the IRS, you have to show the IRS where they overpay, where there is an overpayment into their system and that they owe you. So can you prove that? There are a lot of 1099s. There's 1099 INT, 1099 OID, and 1099 miscellaneous, 1099B, 1099A, 1099. What's the other ones called? There's a couple of them. SEC, something like that. There's a lot of 1099s. I want to know. Because if you want to move like people who use assets, then first you got to obtain asset. Right? Obtain your assets. All right. Now, once you obtain assets in the trust, now you're able to create a promissory note backed upon those trusts. If you do it that way, sure, you can go pay for whatever you want to. But you're going to have to make sure that you stating that those assets are considered as what? Collateral in order to use to get the money that you're trying to get, which now falls upon the secured interest, which now means that you need to do what? Claim all with the promissory notes, claim everything that deals with the obligations to be fulfilled on the terms of you giving these things in secured interest. But just because you gave those things doesn't mean you're not receiving something. You're receiving all obligations that they're supposed to fulfill as secured interest too. So remember, we're giving and receiving at the same time. Every time. Every single time we're giving and receiving consideration, value and consideration. What was the value and what is the consideration being given? Meaning, what is the exchange, whether it's goods, services, or product? What is being given and taken in this particular transaction? Because there's always an equal exchange. Life is built on equal exchange. Everything about energy is on equal exchange. That's another thing. I just want y'all to get it. Facts. And we are the biggest asset in this particular thing. So, and this is why I tell you guys to do what? Like, learn business though. Because if you know that this country / government / corporation, whatever, fully acts in commerce, and everything about it assumes, because I told you, even when it comes to your driver's license and stuff like that, you are a self-employed driver for hire. That's the default. See, in commerce, there has in what they call presumptions. They can only presume the default mechanism until you choose something else. No difference than you turn it on a video game to play, and it says choose your default settings. Now, they already got something by default that you can just click and start playing, or you can make an expression and change the settings, right? This is the same thing. So we have to make sure we come into the fruition of this, because once I figured out there's a such thing. Once I figured out there's a such thing as intangible property, right? This is what I've realized. It's like, okay, there's a such thing as intangible property. So now that means that my name is valuable. All right. Even my weight. Yeah, the number that you put down for weight, that's valuable. That's source data. All of this is valuable information, and you should convey it into your trust and treat it as property, and that anybody who wants to use it, leverage it. It's yours. And don't say, oh, well, that's not possible. Listen, man, I've been playing NBA Live since NBA Live came out, before y'all jumped to playing NBA 2K. And I remember even Bulls versus Blazers. I remember Michael Jordan name could not be put on the actual on the game. That's just like Charles Barkley. You can't put his name on there. That's just like what's the other dude to be talking with Gilbert Arenas? I can't think of his name. Light skinned dude. His name is not on NBA 2K either. So Charles Barkley ain't on NBA 2K. Dang, what's his name? I know his name. Y'all know him too. Light skinned dude, and I can't think of his name off the rip. But anyway, he liked to fight. So if you know who I'm talking about. But anyway, his name is not on there either. All because that's part of source data, and you can't use it. If you can't use it, you can't use it. Bill Belichick, that's another one. He's not on the NFL. Can't use they names. So I remember playing with Michael Jordan, and it just used to say player. And you couldn't even use the number 23. He was number 89. Think about that. They couldn't use the number, nor could they use the name. And he was number 89, but he was bald head. It looked just like him. He had the reverse layup and all of that on there. But again, Kenyon Martin. That's his name. Kenyon Martin. He's not on there. And he said, hey, if you ain't going to pay me to use my name, then why put me on there? You see what I'm saying? That's what I want you to understand about your name, about you, about the stuff I've been telling you. Even your signature should be conveyed. Your autograph should be conveyed. Mm-hmm. Somebody finna say something that ain't got nothing to do with anything. Yeah, that's Cincinnati Finest. That's the school he went to, Cincinnati. I couldn't think of it because that's when they was balling back then. Did they win that year? Did the Cincinnati Bearcats, did they win? I know they was in the Final Four or something like that. So, yeah. Yeah, but and then also, guys, do you not know your name is what they call the street name in banking? And they use that. I hope you know that too. Yes, we are the source. I truly agree. They know that. They know that. They know that. Man, I just appreciate y'all, though, man. For real, all the love that's out here with everybody, man. I'm going to conclude because I got to get back on here tonight. So I want to say some stuff for the night about what we're going to be talking about as well. But after this week, next week, we're going to be going over security interests and stuff like that to show y'all like how to claim those type of things. Because again, obligations and contracts are collateral to you. Okay. And that means that they have to be performed. Obligations is a form of intangible property that you have a rights and interest to in that needs to be fully performed for you. We have to learn to make these claims on the obligation as collateral, the lease as collateral, the security deposit as collateral, and all of this is for the possessory rights of the actual unit. And remember, the address itself, again, I keep saying this, is a form of property. If you claim it, you in control of it. If you don't believe that it ain't, then why do the police look at a particular mill and say, hey, this person lives here. Your name is on your address. And you know why? Because of bearer. There's only two forms that you can own something or hold something or be in control of something. By bearer, which means automatically, since I'm holding this phone in my hand, it's only right that by presumptions, okay, which is the base default, bearer. That is the default. So by me bearing this phone in my hand, you can only assume or presume that I'm the owner, right? But if there is a title or registration of this phone that says difference, all right, that's it. That's the only two ways this can happen, by bearer form. And as far as I'm concerned, I ain't seen nobody making no claim And that's why I say they automatically assume that you live somewhere because your name is on the address, which means you are a bearer of it. So that's the reason why I keep saying, like, okay, let me put y'all in them. Let me show y'all the power of what I'm saying. I got a mailbox. The mailbox is also right now. They say that, okay, it's for federal use. That is true. It is for federal use, but it's still in your control and of your property. And unless you have any form of contracts with people, nobody should be soliciting to you in your mailbox using your address because you didn't give them permission to use that particular address that you are in control of. Notice I said control. I know you didn't create it. I know you didn't, but you are the one that's in control. You didn't create this body, but you in control of it. You didn't create the air that you breathe, but you in control over it by the way you exhale and inhale. You see what I'm saying? So you're in control. And all you have to do, if you're the one that's in control and use of it, it's just like you occupying a specific space, just showing that you have the possessory rights. Here's the question. All these people soliciting in your inbox, did you give them permission? I mean, in your mailbox, did you give them permission to use it? Did you give them permission to use it? You give anybody permission to solicit to you? If you didn't, we got some invoices and a notice of liability. So you got that credit offer saying, hey, you could be afforded $10,000 or $10K or $5K. Yeah, let me send you this letter because I want to know who gave you permission to use. Who gave you the permission to use this property since I'm in possession of it? And since you don't have permission, first thing we're going to say is cease and desist. But you didn't already cause the damage, so there's a little form of restitution. So I see your offer here. And we're going to send you an invoice in that offer. How much you asked, how much you was trying to give. Because again, remember, they use your name. That name should be conveyed into the trust. Did they have permission to use that name and send to your address? I'm just leveraging what's mine. So that's just like if I come to your house right now and then I just take some off your porch without telling you nothing. I just took it and I just go to using it and I used it and it made me money. And I brought it back to you. You found out. What you gonna do about it? What are you gonna do about that? So let that ponder on your mind for a little bit, man. And we're about to ride up out of here. Make sure you guys are following us on YouTube and God We Trust Academy, Twitch and God We Trust Academy, Facebook, Eric Ingham Bay as well.
Through all the struggle we making it in the kitchen trying to take to the street, man, get rich and kick and get, man, the catfish took the whole street, no flounders, y'all ain't seeing me, them babies, man, they gotta eat, so it's real when a nigga ain't owe me, say it's real when a nigga wanna take from me, boy, I lay my head on English Street, them 5 points all in me, my blood niggas, they gotta eat, on the hill, you straight for life, if I make it, we take.
You made me want to go play that song right now. If you pay me.
Still my niggas just getting night, cause the government ain't acting right. Got some cousin locked up, seeing light. Got pedophiles out run the street. That's the reason I take 2 to 3. You fuck with me and I fuck with you. All my niggas guaranteed to eat. All I ever wanna do. Take 2 to 3, you know it's true.
Take 2 to 3, you know it's true.
I gotta feed my babies, man. I gotta feed my babies.
I gotta feed my hood too. I gotta feed my hood too. All I ever wanna do. Take 2 to 3, you know it's true. I talk like I'm water whipping. God, I'm gifted my dimension away from all you niggas. Death to the gun off all you niggas. Death to the guns off all you niggas. Hell for the gun, got a handful of bud and an air full of drugs, been doubtful nigga. Roller nigga.
30 bricks and my word is spitting and I hurt your bitch.
And it's all too killer.
36 in my dirty kitchen, I just started fishing.
And that's boss little nigga.
Work my wrist just to merge the shit, I gotta work to live.
I got scar little nigga.
I just burnt the bed and with the earth I'm giving from the weed man.
Sippin' hard my liquor.
I been in control of shit. Y'all just not noticed it. Check out my actions, I'm focused, bitch. Fuck boys and flunkies ain't fucking with. Cash in the swagger, hot poker chips. Tryna go large just to soul assist. Overdose on that syrup I'm rolling with.
Oh Lord, these nigga right
All I ever wanna do, all I ever wanna do, take 2 to 3, you know it's true. Take 2 to 3, you know it's true. Gotta feed my babies, man. Gotta feed my babies. Gotta feed my hood too. Gotta feed my hood too. All I ever wanna do.
Make sure y'all lock in with us tonight, 6 p.m. Central Time. We'll be back here again, and we're going to be finishing up the civil procedures. This is the last part of it. So hope to see you guys there. And, yeah, man, we're going to make it happen again. So, again, 6 p.m. Central Time. Do follow us there. Meet us there. Greet us there. And, yeah, going to have a great and beautiful time. Anybody that's interested in setting up a trust, as you can see, just follow the directions that's here, right here. Take the flyer. Take your time. Also, guys, we're about to have our academy up, our school up this before the end of this month is over. So you will be able to register. And I know a lot of you guys feel like we be here and there in different classes when it comes to work sessions, but Teachable is going to allow you to be able to go into certain specific subjects. All the different classes I have about that, you're going to be able to go in it and fully just focus on that particular subject, right? So that is what's coming to you guys as well. There will be a payment plan for those of you that are concerned. So we're going to make sure that it's a full payment plan for you and all of that as well. So I just want to make sure that everybody gets what's needed. But if any of this does not fit your budget, well, we're always here doing this for free. So just make sure that you tune in as much as possible. Go down everything that you see on my page. Check as much out as you can. And that's it, man. So y'all have a great and wonderful